Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our legal system, our justice system, and how they intersect with the citizens of the town of Colonie. Today, we're truly fortunate to be joined by Colonie native and resident Michael O'Connor, attorney at law. Mr. O'Connor specializes in bankruptcy law and has maintained a distinguished practice in that field for over 30 years. As many of us know, bankruptcy issues are visiting us daily through the news media and sometimes even in our own neighborhoods. A variety of questions are often sparked by bankruptcy law issues, and we're fortunate to be joined by Mr. O'Connor today. Mike O'Connor's background includes graduating from Shaker High School, Siena College, and furthering his studies for a Master's of Business Administration at the University of Dublin, Ireland, Trinity College. We're very fortunate that Mike has joined us here so that we can discuss some very salient issues about bankruptcy here in the state of New York. Now, we all know there are many levels of courts in the state system and in the federal system. I preside here in the Colonie Town Court. However, bankruptcy law is primarily practiced in federal court, in federal bankruptcy court. Mike, tell us about the federal bankruptcy court.
The entire country is established in certain federal circuits. New York is in what they call the Second Circuit, which includes the states of Vermont and the state of Connecticut. So those three states comprise the Second Circuit Federal Court District. And within the Second Circuit, in New York State, we have 4 districts: Northern, Southern, Eastern, and Western. We are in the Northern District of New York in Albany. And there are 3 bankruptcy courts in the Northern District of Albany, one in Albany, one in Utica, and one in Syracuse. And there's 3 sitting judges in each of those cities. My practice primarily involves appearing in the Albany Bankruptcy Court, although I do appear in Utica from time to time.
Well, and certainly your practice is headquartered here in Corporate Woods, is that correct?
Correct.
And the name of your firm currently?
O'Connor, Brzee, and First. I'm very fortunate to work with some great people. I work with my brother Terry, and Diane Brzee and Dennis First, and we have several associates as well.
Well, your family's had such a profound impact on our community in so many ways, especially in a variety of professions. Your brother Pat was a classmate of mine at Shaker High School, and he's now an MD. I believe is it Pennsylvania or?
Pat is the chief of medicine at Yale University. He's on the faculty at Yale. And
he's in Connecticut.
Right.
Well, he's been certainly one of our distinguished native sons here, just like the rest of your family as well. And I know you went to Shaker High School. Siena College is proud to call you an alum.
Correct.
And you had an interesting postgraduate experience. Where was that?
I always wanted to get an MBA. I always liked business. My dad used to run the Merrill Lynch office in Albany for a very long time. And I had an opportunity to go to Trinity College in Dublin, Ireland. They, at that time, were taking 1 American a year. It was a very small class. It was 20 students matriculated in the MBA class each year. It was a 2-year program back then, I believe. It's now a 1-year program. But it was an interesting experience. I lived at campus in my first year. Then I lived and worked at a bed and breakfast my second year. But the school has a lot of history. It was founded in 1591 by Queen Elizabeth I, and it was a pretty neat experience.
Well, all those educational experiences have certainly culminated in a very exciting career in bankruptcy. Many people are curious to know, Mike, the demographic, or is there a typical person that actually comes and presents for a personal bankruptcy?
We see a wide array of debtors, people that are struggling with financial issues. My most common client in recent years has been elderly couples, people living on a fixed income. What's happened in particularly recent years, the cost of everything has increased. While the income, the Social Security, the pension, that's remained the same. Energy costs have gone up, food's gone up, and a lot of people, particularly elderly people, have been struggling making ends meet. And unfortunately, in many of those cases, they've lived off credit cards. And, with the idea that, things will get better, they'll be able to pay down those credit cards and get out of debt, just doesn't happen. I also see a fair amount of single mothers who are sort of stuck in a similar situation. Oftentimes, they're working, they're getting perhaps some child support, and it's just not enough to make ends meet.
Well, I know that as an attorney, I recall approximately 3 years ago, there were federal law changes regarding bankruptcy. And the idea, the notion was it was going to become tougher to file for bankruptcy. Have the federal law amendments 3 years ago have had any impact at all on bankruptcy filing or on who is entitled to file as opposed to the prior law?
A little background. There was an effort to change the bankruptcy laws over the past decade. There was an entity known as the Bankruptcy Review Commission that was set up in the 90s to sort of make suggestions to Congress on how to revise the bankruptcy laws. There was a sense in the credit community that bankruptcy was too easy. And that kind of escalated into a concern that there was rampant abuse in the bankruptcy system, that debtors weren't being honest, that bankruptcy judges were perhaps acting a little too independently and they weren't following the strict letter of the bankruptcy code. And there was an intensive lobbying effort by the credit community. I understand they spent about $80 million to get this bill passed through contribution to our elected officials and things such as that. But it finally did take effect in October of 2005. And it really brought about significant changes in the way we practice. And the idea was to make the courthouse doors a little smaller, make it a little more difficult for people to have access to the bankruptcy courts. And they did that in a number of ways. Perhaps the most significant way was they developed a new sort of entry test. It's called the means test. It's an analysis of income and living expenses to determine whether someone is eligible to file a bankruptcy. The real effort was to have people go into debt reorganization plans rather than straight bankruptcy. If I can just digress a second. Consumer bankruptcies basically have two forms. One is called a straight bankruptcy, which is a Chapter 7, which is known as a liquidating proceeding. If somebody has non-exempt assets, we can actually sell those assets, use the money to pay the creditors. The other form of relief for consumer debtors under the Bankruptcy Code is a Chapter 13. It's called a debt reorganization plan, which is a lot of people take advantage of if they're behind on a mortgage or if they're behind on some car loan payments. But, some people just like to file the reorganization plan because they feel as though they're doing the right thing. They're making some payment back to the creditors. Now, that payment may only be 5 or 10 cents on the dollar, but at least they're making some payment. The thrust of this new law was an expectation that it would force people into the debt reorganization plan rather than the Chapter 7. And on the eve of the passage of the law, I mean, the number of filings in Albany in that August, September, first part of October went sky high. There were an unbelievable number of filings. And then it tapered right off once the new law took effect. But what's happened is it looks as though the Congress missed its mark. One, I don't think there's been any significant evidence of any abuse in the system. And it just doesn't seem to be working out the way they expected. I think the filings have now got up to the point where they were almost just prior to the enactment of the new law. And the effort to sort of force people into the reorganization option really hasn't materialized to the extent that they thought it would.
There are those that question the effect of bankruptcy. They see people who file for bankruptcy and the next day they're driving a new car. They think the system's being abused, and how can that really work? And maybe sometimes that's more involved with commercial bankruptcy, where someone has filed, their company's gone bankrupt, but the next day they're opened up, they've got a sign out they've just changed the name, but it's the same person, and it looks like a shell game to some. Is there any validity to that assumption or belief?
I don't think so. On the consumer side, I think there's a shared responsibility between the debtors and the credit community. Let's face it, up until very recently, particularly the credit card companies, and to some extent the mortgage companies, were on a lending binge. I mean, people were getting credit that had no business getting the credit. Now, are you going to penalize the debtor, the borrower, because they're in that situation? I don't think you can. I mean, I think, again, the creditors, I think, have to share some of the responsibility. On the unsecured debt, on the credit card debt, I mean, you know, my college-age daughters are getting credit solicitations.
That's right.
They're not working.
That's right.
You
know what I do with them? Throw them out.
Correct. And on the mortgage end, I mean, there's this whole mortgage mess. You know, you can point at the debtor and you say, well, you know, the debtor's gaming the system, abusing the system. A lot of those mortgages that were given over the last 10 years should have never been given. I mean, the credit community was just doing everything it could to get that money out there, and unfortunately, it's had some unfortunate consequences.
Have you seen abuses ever in the system where even you looked at that and either someone's a repeater? I mean, could someone file for bankruptcy every 2 years, or are there other ways that there's a perception of abuse?
They've changed that. That's one of the changes in the new law. There's an 8-year time period now in between bankruptcies. As far as abuses, I don't see it too often. The consequences are significant. Particularly if there's bankruptcy fraud involved. If somebody doesn't disclose assets, intentionally doesn't disclose assets, or perhaps transfers assets without disclosing the transfer, again, there has to be an element of intent there. In those types of situations, it's a federal crime, and it's a crime that they have prosecuted in Albany.
I know there may be a belief by some that you can dispose of all your property on Tuesday, and then Wednesday go file for bankruptcy, and you don't, and you've given all your property away, and you can then somebody will give it back to you 2 months later. That actually isn't true, and there are mechanisms to actually control someone's ability to rid themselves of assets prior to bankruptcy. Is that correct?
Again, that type of activity would result in a couple things. One, perhaps some criminal prosecution if it wasn't disclosed. And two, people file bankruptcy to get something called a discharge, which is a final order in the bankruptcy process that absolves you of your debt. That type of activity could result in the denial of that discharge. So you filed a bankruptcy, your credit rating's taken a shot,
right,
and then you come out the other end without that discharge. And as far as transferring assets or disposing assets, as a bankruptcy trustee, I can go back 6 years to recover some of those transfers. I had a case a few years back where an individual owned a retail store in Lake George. They also owned a house right on the lake worth maybe $1.5 million at the time. Today, in today's dollars, it'd probably be $3 million. He transferred his interest to his wife about 5 years before he filed the bankruptcy. Now, at the time he transferred his interest, there was significant equity in the property. I was able to reach back 5 years and recover that equity for the benefit of his creditors. So, you know, as far as transferring assets, you really have to, one, disclose the transfer, and two, be prepared that the transferee might have to give back the asset.
Now, you brought up a very interesting point, and which only underscores the length and breadth of your own background and experience. You are also appointed by the Justice Department annually to serve as a trustee in bankruptcy.
Correct.
And what does that mean?
A bankruptcy trustee basically oversees the administration of individual bankruptcy cases. I was fortunate enough back in 1986 to get appointed by Judge Justin Mahoney to be a bankruptcy trustee. In 1987, that appointment process was changed where the Justice Department took over the appointment process, and now we're reappointed on an annual basis. We've been very fortunate in the Northern District of New York, and particularly in the Albany Court. We've only had 2 judges in the past 40 years, Judge Mahoney and Judge Robert Littlefield. Judge Littlefield is a local homegrown attorney. He went to Shaker, and he's been a sitting judge since 1995. So as far as getting appointed as a trustee, that's done on an annual basis. And typically what happens is I'm what they call a Chapter 7 trustee. I have anywhere between 60 and 80 cases a month. These are people who filed bankruptcy. There's a random assignment. There's 6 or 7 bankruptcy trustees in Albany, and we go all the way, we take cases all the way through Washington County, Warren County, Schoharie County, Greene and Columbia, Schenectady, Saratoga, Rensselaer. And I get the papers, I look through the papers, see what assets are there, see what debts are there, and any other information. And I follow that up usually with a letter to both the person that filed the bankruptcy, we call a debtor, and the debtor's attorney. I want additional information. I usually want to see bank accounts, tax returns, information on ownership of property. And then there's what they call a meeting of creditors. Now, it's sort of a misnomer. And a meeting of creditors sounds somewhat intimidating. Someone's going to file bankruptcy and all these creditors are going to gang up on them. It's very rare that any creditors ever show up at these meetings. For some reason, they've kept that name over the years. So it's my role as a trustee really to ferret out the issues and facts to determine whether there's any assets available for creditors. And that hearing takes place in the O'Brien building in Albany, and I'm assigned cases 1 day a month.
Well, I know that many people wonder if they file for bankruptcy, are they allowed to keep anything that they brought into the bankruptcy court? Does the state or federal government exempt certain items of personal property or real estate that they can keep and which is shielded from creditors?
Under the bankruptcy law, they set up a system of exemptions. They're federal exemptions when the law was first enacted back in 1979. The law also had a provision in it that said certain states can opt out of the federal exemption scheme, and New York did opt out in the early 80s. And it said, we decided we're not going to avail ourselves of the federal exemptions, we'll take the state exemptions. When I first started practicing, we could choose. We can either choose the federal or the state exemption, depending upon which one benefited our client the best. But when they passed the opt-out legislation in New York, we just had to take the New York exemptions. Initially, the New York exemptions were rather modest. Property that you can keep. The homestead exemption, that's equity in your house, was $10,000 per owner, so husband and wife, $20,000. They changed that back in August of '05. They increased it to $50,000 per homeowner, so husband and wife, it's $100,000. That's a pretty generous exemption. That's equity that you can keep in your house. If you owned a house worth $225,000 and had a mortgage of $125,000 owned by husband and wife, you can keep the house. You can file a bankruptcy, and that $100,000 of equity you can retain. Also, vehicles, you can exempt up to $2,400 equity in a vehicle. If you bought a car, the car's worth $20,000, and you owe $18,000 on that car, you can keep it as long as you can keep up the car payments. That equity doesn't exceed the $2,400. You can keep cash up to $2,500. Retirement assets, you can keep an IRA up to $1 million. So I would say in about 5% of the cases that I see as a trustee, people have non-exempt assets. They have assets that exceed the value of the exemptions. So in 95% of the cases, their assets are within the exemption. So it's usually not a big issue. But sure, if you have some assets that exceed the exemptions, I'll take them, I'll sell them. I mean, I as a trustee, I have sold houses, I've sold businesses, vehicles. I once was a trustee in a dude ranch down in Greene County, and they had 90 horses. And all the farmhands walked off the dude ranch. So I was in charge of feeding these horses. So, I mean, you get some interesting cases. I had to hire back some of the people that worked there and put them on, I had to pay them, and I had to actually sell the horses.
Because to some degree, as a trustee, you're trying to protect the asset to maximize its value for the benefit of the creditors.
Exactly. And we have to do that in an expeditious fashion, too. We can't let the assets languish. We have to identify what the assets are and then try to find a buyer.
Is it fair to say that every bankruptcy proceeding, there's a trustee involved?
There is in consumer bankruptcies, in
Right.
Chapter 7 and in Chapter 13 debt reorganizations. An individual can also file a Chapter 11, which is a business reorganization. Initially, when someone files a Chapter 11, they're called a debtor in possession. In other words, there is no trustee involved. However, if the creditors want to put a trustee in and there's cause to have a trustee, for instance, there's concern about maybe the business being run properly or some assets
Right.
perhaps disappearing,
They can petition.
they can request a
right.
trustee gets appointed.
Wow. Do you see that, are there any other pieces of personal items that people can keep that are exempt from creditors in a bankruptcy proceeding?
Well, in New York, we've had a lot of exemption laws on the books for decades and for centuries. Bibles.
Okay, the family Bible.
Yeah, tools of the trade, limited up to $600. Certain value on a wedding ring. And I think somewhere in the books there's still a livestock exemption. But for the most part, it's household goods, furnishings, things like that. You can keep up to $5,000 worth of those items.
Now, you mentioned at one point today that in a bankruptcy situation, it's possible that if someone has $2,000 worth of equity in their automobile, but they owe $18,000 more, they may be able to keep that automobile as long as they keep making the payments.
Correct.
Well, weren't the payments part of the reason why they went into bankruptcy and they can't afford the payments?
That's a good question. Generally speaking, it's unsecured consumer debt that drives the bankruptcies, credit cards,
Right.
medical bills, things like that. You raise a good question with a car, though. One of the options that people have, we've talked about the Chapter 7 bankruptcy, is the debt reorganization plan. Interestingly, in most of these car loans, it's rare that there's equity in the car. The car is usually worth $5,000, you owe $15,000 on the car loan.
Right.
There's an option in the debt reorganization plan where you can actually restructure the car loan, pay him back $5,000, not $15,000, and actually benefit the debtor. I mean, reduce the payments. There's some requirements that have to be met to be able to do that, but that's an option that people have sometimes in a reorganization bankruptcy.
Now, Michael, you've been involved in so many different bankruptcy proceedings, and which have brought you far and wide here in the federal district. But one close to home, which I know that our audience would love to hear about, is the bankruptcy filing involving our Boston store that many of us remember at the Latham Circle. And I wondered whether you could tell us anything about that.
Occasionally we get involved in business reorganizations and business bankruptcies. Two local stores that I've been involved in was Standard Furniture and the Boston store. The Boston store, of course, for growing up was the anchor of the Latham Circle Mall for years and years. It was a unique department store. We used to go there to buy our Levi's and whatever else when we were in high school. And they ran into some tough times and attempted to reorganize. Ultimately, they had to file, they had to go into a straight bankruptcy. And, it was tough because they employed a lot of people locally. And,
That's right.
And it was a key tenant to that mall. And when a business like that goes out, it affects a lot of people. And it's funny, I've gotten involved in a lot of business bankruptcies as a trustee as well. Once I had a fellow with a yacht down in Florida, and I had to meet an auctioneer down in Florida. I had to fly to Key Largo to meet this fella and look at the yacht, and we ended up auctioning it off. Another time I had somebody who filed a bankruptcy that owned property in Ireland. And, of course, I'd spent 2 years there in graduate school. And I wasn't getting straight answers about some of the value of the property and the location of the value and other indicators what the property was worth. So I requested permission to travel over there to retain a solicitor, to retain a realtor, and to sort of look at the property to see what I had. So I've, as a trustee, I've been able to do some traveling as well. It's been sometimes pretty interesting.
Well, you probably also, as many of us who are involved in the court system see, oftentimes there's heartache involved too at some point.
Well, there is. I mean, you know, and I see it both as a trustee and both as an attorney for clients. I mean, no one wants to file a bankruptcy. There's a tremendous amount of guilt. You feel as though you failed. But on the other side of the coin, the bankruptcy has been it's in our U.S. Constitution. I mean, it says Congress can enact laws, bankruptcy laws. So it's been with us for a long time. And it serves a purpose. I mean, back in the day, in Charles Dickens' time, I mean, you used to go to prison.
Correct.
You couldn't pay your bills.
Debtor's prison.
Correct.
Yeah.
But so the bankruptcy, you know, there's a tremendous amount of guilt and there's embarrassment and shame. But usually after someone files, the response is they feel as though a tremendous weight's been lifted off their shoulder. And they can start rebuilding their life, and usually the opposite emotions occur.
Right.
You know, and it's difficult. I mean, you know, I see, you know, husbands and wives come in, 3 or 4 children, and, you know, they're trying to plan a future for their family, and you know, a husband or wife gets laid off, somebody has some, you know, unforeseen medical issue
Sure.
that impacts the ability to earn income, and they just can't make their payments.
Have you seen it accomplish a very positive situation in one's life where some years later they are unbelievably positively impacting and contributing to the community, and that actually the discharge they received through the bankruptcy court actually helped accelerate their positive impact on the community?
Absolutely. I mean, I've seen that many times over, particularly with small businesses. I got a young business person who maybe made an effort to start a business, ran it for a few years, and it just didn't work out. But there was something in their character where they really had the ability to run the business, the wrong place, wrong time, and they've come out of the bankruptcy and gone ahead and started all over again and been very successful, employed a lot of people, and been able to get off the ground with a good business.
Based on your practice and experience, are there any other amendments or proposals that you think should be considered by Congress in order to enhance the bankruptcy laws in the United States?
One of the items that came up during the presidential debates had to do with this mortgage mess that we're in, and you know what the solution is. President-elect Obama had a unique solution where he specifically focused on the bankruptcy laws. His idea was to go into bankruptcy, amend the bankruptcy code, and perhaps let homeowners be able to modify their mortgages in a bankruptcy proceeding. And it would, I think, be very beneficial to debtors if they're able to do that. Let me give you the example. What he's focusing on is situations where somebody might owe $200,000 on a mortgage. Well, the property's worth $140,000. A lot of times, unfortunately, with some of these mortgages, they were appraising these properties far above their actual value just to make the mortgage financing work. I mean, you know, even locally, you've seen some people get indicted and sent to jail for getting involved in those types of schemes. Well, there were situations where, you know, somebody might have a $200,000 mortgage on a house worth $140,000. The president-elect's position was, well, why don't we modify the bankruptcy code and let the homeowners, rather than lose the house to foreclosure, restructure the mortgage, pay back the bank the value of the bank's collateral. After all, what's the bank going to get if they foreclose? They're going to get the value of the collateral, the $140,000. So why not let the homeowner keep the property and repay back the value of the property? That is one of the items that I know is on his agenda, but you know, it took so long for that last bankruptcy reform legislation to get passed and to take effect. It's going to be interesting to see if that legislation will see the light of day. But
well, we all hope that you stick with helping guide the body of law known as bankruptcy law here in the Capital Region. We've been so very lucky to have Michael O'Connor here today, who is a specialist in bankruptcy law, practicing here in Colonie and living as a native in Colonie and raising his family here, and what dynamic children you have as well throughout the community. Thank you very much for joining me, Michael, today.
Peter, thank you for the opportunity.
Well, we look forward to seeing you again.
Thank you.
I'm Judge Peter Crummey, and thank you for joining me on Benchmark.
Welcome to Channel 17, the Town of Colonie Government Channel.